Ready? Start. These contractors engaged workers through Zamadars who brought them from different parts of India, particularly the state of Rajasthan, Uttar Pradesh, and Odisha, and paid to these Zamadars the minimum wage of rupees 9.25 per day, we worker, and not to the workmen direct. The Jamadars deducted rupee 1 per day per worker as their commission, with the result that there was a violation of the provisions of the Minimum Wages Act, the provisions of Equal Remuneration Act 1976 were violated, as the women workers were being paid rupees 71 per day. The balance of the amount of the wage was being misappropriated by the Jamadars. There was violation of Article 24 of the Constitution and of the provisions of the Employment of Children Acts 1938 and 1970, in as much as children below the age of 14 years were employed by the contractors in the construction work of the various projects. There was violation of the provisions of the Contract Labor Regulations and Abolition Act 1970, which resulted in deprivation and exploitation of the workers and denial of their right to proper living condition and medical and other facilities under the Act, and the provisions of the Interstate Migrant Workmen Regulation of Employment and Conditions of Service Act 1979. Public interest litigation, which is strategic arm of the legal aid movement and which is intended to bring justice within the reach of the poor masses who constitute the low visibility area of humanity, is a totally different kind of litigation from the ordinary traditional litigation, which is essentially of an adversary character, where there is a dispute between two litigating parties, one making claim or seeking relief against the other, and that other opposing such claim or resisting such relief. Public interest litigation is brought before the court not for the purpose of enforcing the right of one individual against another, as happens in the case of ordinary litigation, but it is intended to promote and indicate public interest, which demands that violations of constitutional or legal rights of large number of people who are poor, ignorant, or in a socially or economically disadvantaged position should not go unnoticed and unredressed. That would be destructive of the rule of law, which forms one of the essential elements of public interest in any democratic form of government. 467 CF 1:2. The rule of law does not mean that the protection of the law must be available only to a fortunate few, or that the law should be allowed to be prostituted by the vested interest for protecting and upholding the status quo under the guise of enforcement of their civil and political rights. The poor too have civil and political rights, and the rule of law is meant for them also, though today it exists only on paper and not in reality. If the sugar barons and the alcohol kings have the fundamental right to carry on their business and to fatten their purses by exploiting the consuming public, Certainly, the chamars to belonging 458 to the lowest strata of society have fundamental right to earn an honest living through their sweat and toil. Large numbers of men, women, and children who constitute the bulk of an population are today living a subhuman existence in conditions of abject poverty. Utter grinding poverty has broken their back and sapped their moral fiber. They have no faith in the existing social and economic system, nor can this poor and deprived sections of humanity afford to enforce their civil and political rights. 467 PH 468 AD 1:3. The only solution of making civil and political rights meaningful to these large sections of society would be to remake the material conditions and restructure the social and economic order so that they may be able to realize the economic, social, and cultural rights. There can be no doubt whatever that so far as religious institutions are concerned, the Act is intended to apply only to religious institutions and endowments which are exclusively Hindu in character. With reference to the endowments created by Seshajala, the final conclusion of the learned judge was thus expressed. After having read the entire document and examined the various considerations urged by the learned counsel for the respondents, I am clear in my mind that it would not be right to say that the institution or endowment set up by the deed of trust is exclusively Hindu in character. That means that Section 3 of the Hindu Religious and Charitable Endowments Act cannot be invoked in relation to this institution. Source is 3P Legal RHC. Exercise number is 53. Words are 760 and speed is 100.